The court is on the record in City of Conneaut versus Amber R. McHenry, case number 24 TRD 527. Court is in receipt of a pretrial report. Mr. Lewis.
Thank you, Your Honor. We may have a resolution of the matter, should the court be willing to accept it, whereby the city would dismiss the fictitious plate charge at defendant's cost, and Ms. McHenry would then enter plea of guilty to the two remaining charges of failure to reinstate, driving under suspension, and expired plates. The city would then recommend whatever fines the court would deem appropriate along with the court costs of the case. Thank you.
Thank you. Mr. Sayaj.
Thank you, Your Honor. I did convey the offer from Law Director Lewis to my client, Ms. McHenry, after extensive talks and going over what she would be waiving today. She has decided today that she would take the plea offer along with the state's recommendation of just court costs and fines.
Okay, Ms. McHenry, it's my understanding today that you wish to change, you originally entered no plea to charges of failure to reinstate an unclassified misdemeanor and expired plates, a minor misdemeanor. You wish to enter guilty pleas to those two charges. In exchange for those guilty pleas, the fourth degree misdemeanor charge of fictitious plates would be dismissed at your cost. Is that what you would like to see happen today?
I believe so.
You understand by pleading guilty to those charges that you would be waiving your right to the jury trial that is currently scheduled at the end of the month, as well as all of your trial rights. We just had a trial last week, so you kind of know what a trial is like. So by pleading guilty to these two charges, you'd be waiving all of those trial rights. Is that what you wish to do?
Would that put an end to litigation?
Yes, it would.
I mean, no.
I'm sorry?
Yes.
Okay. Also, you are represented by Mr. Sayaj. Have you had sufficient time to consult with him, and are you satisfied with his counsel?
Yes.
Okay. I do find that defendant's pleas of guilty to these minor and unclassified misdemeanor offenses in subcase A and B, failure to reinstate and expired plates, to be knowing, voluntary, and intelligent. The court will accept the guilty pleas to those two charges, and I will therefore find her guilty of those offenses. I will dismiss at the defendant's cost the fictitious plates charge in subcase.
After previously insisting that the court had no authority over her and delivering a long emotional message online, she now appears to be changing her position and acknowledging that laws do in fact apply to her and that she may have broken some of them. This sudden shift raises an important question about whether this change is genuine or simply a strategy meant to move the case toward its conclusion as she described it. The court cannot easily determine if this is a sincere acceptance of the legal process or just a temporary approach designed to avoid further conflict during the proceedings. Because of that uncertainty, the judge remains cautious and carefully addresses the situation in the courtroom. With that in mind, the judge issues a clear warning to make sure she understands the seriousness of the case and the expectations moving forward.
Ms. McHenry, I did not impose community work service. I could have. I did not impose a Class 7 license suspension. I could have on the failure to reinstate charge. I've just given you a fine and cost, although I'm ordering you to provide proof of insurance on the vehicle you're driving that day. If you're not able to provide to the clerk proof of insurance on the vehicle you're driving that day, you are subject to what we call a non-compliance suspension with the Bureau of Motor Vehicles. I guess what I'm saying is, Ms. Kennery, I could have sentenced you in a much more severe way. I did not, but understand that if you're back here with similar offenses and you're found guilty of those, I will impose those. What I didn't do today, I would do at a later time.
As mentioned earlier, we will soon discover whether her attitude has truly changed or if this calm behavior is only temporary while she moves through the courthouse process. Time will reveal if she continues respecting the law once she walks out of the building and returns to everyday life. For the next hearing, we travel to Georgia, where another courtroom moment is about to unfold under the leadership of Judge Tammy Hayward. Many viewers enjoy watching her courtroom because she speaks with patience and calm authority while addressing people who clearly misunderstand the law. She has a steady way of explaining the facts and reminding individuals that confidence without knowledge will not stand strong inside a real courtroom.
Next case is LaTanya Denise Turner versus Brian K. Widener, State of Georgia, Salah Holdings, Delphine Gresham, and Larry W. Johnson. All right, is there Ms. Turner, LaTanya Denise Turner?
Yes, I'm the attorney, in fact, on behalf of the principal, who is the resident agent. I have also already submitted forms appointing the judge over this matter to administrate on behalf of the principal. And I also submitted the rest of my entries on records. Now, with that being said, the Form 56 appointed judge.
Ms. Turner, I gotta see you first.
Okay. I'm trying to, there I go.
Okay, there you are. All right,
Okay.
so Ms. Turner, very quickly. I've reviewed the information that you provided. First of all, you're suing with respect to a foreclosure, which is a situation that involves land and a determination of ownership with respect to land. That is not my jurisdiction. I'm in state court. State court does not have jurisdiction over determinations of land. We deal with dispossessories, which is a temporary situation with respect to land, the allowing someone to use your land in exchange for rent or your property in exchange for rent. But we do not deal with the whether a foreclosure is proper. So in this case, this court is going to have to transfer your case to the Superior Court of Clayton County, depending on whether this is Clayton County that's involved. And so I see you're suing the state of Georgia. Not sure how they're involved. Not sure how any of these parties are really have an interest in this case. But with respect to the jurisdiction for foreclosures, that is not what I do. Okay. All right. Is there anyone else here on behalf of any of the other parties who either disagree with what I've said or who have anything that they would like to put on the record?
So, Your Honor, this is Larry Johnson. I represent Brian Widener as well as myself. I just want to point out to the court, this was initially filed and I was not named.
Okay.
And after I filed an answer on behalf of Mr. Widener, the plaintiff just stuck my name and added it to it without a court order. And at that point in time, she needed a court order. So I'm not personally, I mean, I'm only in this case because I filed an answer for Mr. Widener.
Name me too.
In the legal system, judges and attorneys are protected by a principle known as judicial immunity when they are performing their official duties in a case. This protection means they cannot be personally sued simply because someone disagrees with a ruling or feels unhappy about how a case was handled. Judges are expected to make decisions based on the law and the evidence presented in court, and those decisions will not always satisfy everyone involved. Attorneys also represent their clients according to legal procedure, which sometimes places them on opposite sides of a dispute. Because of this structure, the law prevents personal lawsuits against them just for carrying out their professional responsibilities during a case. This rule exists to allow courts to function properly without constant personal legal threats against the people responsible for running the justice process.
So, Ms. Turner, I know you have a set of beliefs about how the law works, but the way we do it here is just because somebody files on behalf of another person, everybody's entitled to have an attorney represent them. And so you can't then sue the attorney for giving them a defense. So everybody who comes into the case doesn't get sued individually. Like there are people who are responsible, allegedly, for what you are contending happened. But then there are other people who they choose to hire to help them navigate the case. For the people who are navigating the case and for the judges who are dealing with the case, you don't get to sue them because they don't have an interest in at that level. They're just trying to help the other person navigate the case, okay?
Could I get finished recording my interest on record?
No, ma'am. You've done that. You're the plaintiff.
Okay. Well, Judge, I would like to record my interest on record.
I'm not sure what that means, ma'am.
It appears that her comments are less about presenting a real legal argument and more about continuing to speak without adding anything meaningful to the case. The behavior gives the impression that the moment is being used for attention rather than for addressing the actual legal issues in front of the court. Instead of focusing on facts, evidence, or clear reasoning, the discussion drifts towards statements that do little to help her position. Moments like this often show the difference between speaking confidently and actually presenting a valid legal point. In the end, the courtroom requires substance and clear reasoning, rather than long speeches that only create the appearance of making a serious argument.
I'm the attorney-in-fact on behalf of the principal, who is the registered agent. I already submitted the Form 56 upon you over the matter to administration on behalf of our principal.
Ms. Turner, nobody gets to appoint me over the case. I'm already appointed to whatever's assigned to me through the clerk's office.
I appointed you through my for my trustee. And Your Honor, I would like to add also to the case and ask you a question.
No, ma'am.
Yes or no?
The question that I'm not going to answer any questions because this is not my jurisdiction. So I'm going to transfer the case to Superior Court and let them sort it out, because land use and land and interest in land is under the jurisdiction of the Superior Court. Okay, so we'll get you an order. We'll also dismiss Mr. Larry Johnson from the case pending whatever the Superior Court decides, because he's only here to represent the defendant, which the defendant has a right to hire an attorney to represent them, and that attorney doesn't deserve to be sued because they are helping somebody defend themselves.
This case is also in the federal court also.
Okay, then if it's in federal court, then it probably doesn't need to be here also. You shouldn't have a case running in two different courts at the same time. Okay, that's just going to cause confusion. And you're not going to achieve what it is you wish to achieve.
Okay, Your Honor, I know this court has no jurisdiction per 12 CFR 1500.
After reviewing the regulation known as 12 CFR 1500, it becomes clear that the text does not even mention the concept of jurisdiction or refer to judges' attorneys or the courtroom process in any direct way. The language of that rule focuses on an entirely different subject, which means it does not support the argument she is trying to build in court. Even though she continues to claim that the court has no authority over her, the regulation she points to does not actually address that issue at all. What makes the situation even more unusual is that she still seems comfortable assuming the courts hold authority over everyone else, while insisting that she alone should somehow be treated differently. That contradiction highlights the confusion in her argument and shows why the court is unlikely to accept that interpretation.
And also, is there or should there be an investment in private residential property in the United States? Or is deposit?
That is a question bigger than any of us can handle. People can invest in whatever they spend their money on. So at this point, I think that you're going a little bit too far afield. Like I said, we're going to go ahead and transfer this case to Superior Court, and my brother or sister judges on Superior Court will help you sort out what it is going on. Okay. All righty. So we'll go ahead and get an answer out to all of you. Get an order out to all of you transferring this case to Superior Court. But just as an aside, Miss Turner, everybody who comes in as a representative of somebody else, if they're an attorney, don't sue them, because it just makes the case harder to get through. Okay, if you want to achieve something with respect to finding out what happened with your foreclosure, don't keep adding people to the
Your Honor, in this executive branch of law, I have a right to sue the attorney, anyone else involved.
Ms. Turner,
in this executive branch, I do have a right to sue them and anyone else involved.
It's nonsense. None of what you're saying makes sense. None of what, Ms. Turner,
it's federal law.
Ms. Turner, we're not in federal court. None of what you're saying makes sense. You haven't established an estate. There's no trustee. You're giving us word salad. You're just saying stuff that you've read or somebody told you was appropriate. It's essentially called a sovereign citizen. But
no, it's not a sovereign. It's No, it's not. I'm not a sovereign
If
citizen.
those things
No,
work,
that
ma'am,
don't put
everybody would
don't
use
put that
those.
on me. I'm not a sovereign
Ms.
citizen.
Turner, you've made statements that sovereigns use, and so I'm
I
telling
have my
you,
trust set up, and
okay,
I'm not a sovereign citizen.
yes, ma'am.
I am a person working in my trust,
Okay, if
not
you
a
said,
sovereign citizen.
all right,
That's
Ms. Turner.
against the law.
Okay,
I'm not a sovereign citizen. I have my trust set up
okay,
in a way that it's working for me, and I have it set up.
okay.
And that's what I'm working on, my trust.
Situation makes it clear that the person involved strongly follows the ideas often associated with the sovereign citizen movement, even though those beliefs rarely succeed inside a real courtroom. Holding those views is not itself against the law, and people are free to believe many different things, even when those beliefs conflict with established legal principles. However, the courtroom still operates according to recognized laws and procedures that apply to everyone who appears before a judge. Simply repeating those theories does not change how the legal system works or how cases are decided. With that moment concluded, the focus now shifts to the next and final case of the day, which took place in the same courtroom roughly an hour later, and introduces another dramatic exchange for the judge to handle.
All right. So, Miss Ebony Milner is present. Also, the Mr. Brown, who's on here on behalf of Federal National Mortgage Association. Mr. Brown, Miss Milner, is my understanding that this was heard in magistrate court, and this is a request for appeal. Is that correct?
Yes, Your Honor. This is a petition for review from a dispossessory judgment. She was a tenant at sufferance post foreclosure.
Okay. All right. So, Ms. Milner, tell me what's going on.
Judge, well, this is a case of land rights, tribal law, and treaties.
No, ma'am. No.
And I would just like to say that I'm a tribal member,
ma'am.
part of the Cash Box Trust Tribe.
At this point, she begins referring to what she calls the Cashbox Trust Tribe, which sounds like another group or idea tied to the theories she has been repeating throughout the hearing. The way it is presented suggests she is trying to give her arguments some kind of official or organized backing. However, statements like this often create more confusion than clarity, because the courtroom focuses on real legal authority rather than labels or groups that have no clear standing in law. Judges typically look for evidence statutes and established legal arguments rather than symbolic titles or self-declared affiliations. As the discussion continues, it becomes clear that introducing these names does little to strengthen her position in front of the court.
No, ma'am.
Governments
No, ma'am. We're not doing that.
and American Indian landowner.
No, ma'am. So we're not doing all that. So this is a simple eviction. So you can tell me how much was owed, how much you paid, whether there's anything to that allowed you to stay in the property, or whether there's money owed to you. I don't do the whole trust, tribe, all of that, because that's not what we
Well,
deal
that's
with
what this is in regards to.
Well, then, ma'am, that's not what we're doing here. I would either have to transfer you to a tribal court, which I don't know of one exists for you, or for Superior Court, because this involves a foreclosure. Essentially, he bought the house through a foreclosure. You were a tenant in the house at the time, or you owned the house and he bought it under the foreclosure. And then it was whether you get to stay in the house and pay rent, or whether you're going to be evicted. Am I clear, Mr. Brown?
Yes, Your Honor. And
Right. Because I don't deal with I went to law school for 3 years, have practiced law for over 30 years, have been a judge for over 12 years. I don't do the trust stuff, because that's some arcane, esoteric stuff that you all believe that we don't follow here in the judicial system.
I understand. Well, I would also like to say that I'm not here to handle any of my private affairs in the public.
Okay, so I'm not sure what that means. You asked for the appeal.
Yes, and as I was stating, I'm a tribal member, part of the Cash Box Trust Tribe, and also an Indian American landowner. So this case is in regards to trust and tribal land.
So the property, the foreclosure is on a house on tribal land.
Correct.
Which tribe?
I'm sorry?
Which tribe?
Just the Ebony
They
Milner
kicked me
tribe?
out.
No, sir. I don't know of that tribe, ma'am. So we even do
Yes,
this
and all the documentation had been put on file as well.
okay,
Post foreclosure.
ma'am. So here's the thing. Like I said, I've explained to you that if somebody purchases a home through foreclosure, then the people who were owners of the home or buying the home have two options. They can leave or they can be treated as tenants in the home. And in this case, it appears that Mr. Brown's client sought to evict you, and now you are asking for a review of that. So in my role in this court, I can go through the case as if it was never heard in magistrate court. But what I will tell you is I'm going to ask very specific questions. I'm going to follow the law under the state of Georgia with respect to landlord tenant. And if you're not able to provide me that information, then I'm going to determine that you're not able to prosecute the case in the way that it needs to be, and I'll dismiss it for want of prosecution.
Well, again, American tribal landowner, so
Okay.
those laws
No,
that you
ma'am.
may speak of don't
No.
apply to me.
Usually in situations like this, people only hint at the belief that the law should not apply to them, and the court is left to interpret those ideas from the way they speak and behave. It is actually uncommon for someone to clearly state on the official record that they believe the legal system has no authority over them. In this case, however, she openly expresses that belief during the hearing, which removes any doubt about the position she is trying to take. By making that statement so directly, she places her views permanently into the courtroom record, where they can be reviewed by everyone involved in the case. Moments like this often reveal just how far someone is willing to go in defending a personal theory, even when it conflicts with established law and courtroom procedure.
Well then, okay, I'm going to dismiss your appeal for want of prosecution. The court does not have jurisdiction over American tribal land, nor is there a designation of this property being a tribal land. So at this point, the court is going to dismiss this for want of prosecution. Thank you. All right, next.
That moment shows how a judge can firmly explain that an argument has no legal foundation and make it clear that the person presenting it does not understand the law they are trying to rely on. Once the court recognizes that the claims have no valid basis, the judge can dismiss the matter and move forward to the next case without wasting more time. Situations like this highlight how the courtroom focuses on real legal reasoning rather than unsupported theories or dramatic statements. With that final exchange, the video reaches its conclusion, and the next chapter of the story will continue very soon. In the upcoming update, the same sovereign citizen, Karen, who previously brought a case and lost, will appear again in court after another arrest, which promises even more unexpected moments.